The seductive logic of law to code, automating the DPDPA. All right, let's jump straight into this explainer. We're looking at a deeply fascinating and honestly pretty politically charged debate right at the intersection of AI, cybersecurity, and India's privacy laws. Let's get to it. So, to really understand this, we have to start with the seemingly perfect, absolutely seductive logic behind the government's proposed plan. Our source quotes this core idea that just sums it up beautifully. AI-powered cyber attacks now operate at machine speed. Therefore, governance must operate at machine speed. Therefore, law must become code. And honestly, when you first hear that, it kind of makes complete sense, right? If we're up against AI threats that literally move faster than human thought, shouldn't our defenses and our laws operate at that exact same speed?
But what do we actually mean when we talk about law to code in the context of the DPDP Act? Basically, it means taking the written legal provisions, the actual text of the law, and converting them directly into automated machine-executable software rules. This software would just automatically process data activities, detect breaches, and enforce compliance, completely without human intervention. You're essentially taking the lawyers, the compliance officers, and the judges out of the immediate equation and just letting the code dictate what's legal and what's not in real time.
But, well, here is where we hit a pretty sharp reality check. Because, while that headline sounds like a sleek, futuristic solution, our source material impartially breaks down why handing the law over to an algorithm without a human in the loop is just full of structural weaknesses. The author puts it perfectly. Regulatory catastrophe lives in the gap between the headline and the implementation. Now, the source doesn't dismiss the ambition here, but it really thoroughly maps out why a working implementation of automated law is just incredibly dangerous. And this brings us to the first major flaw. Legal language is structurally ambiguous. Ambiguous terms in the DPDP Act include things like reasonable security safeguards, permissible purposes, sensitive personal data, or significant data fiduciary. You see, the law is built to be ambiguous on purpose, to accommodate the messy, infinite variety of human reality. These phrases don't have a clean mathematical definition, right? They're deliberately flexible so courts can interpret them based on real-world context. But you just can't cleanly map human context into deterministic binary software code. Code needs a definitive yes or no, while the law, well, it mostly operates in the realm of it depends. Let's actually look at how this plays out when a programmer sits down to write this software. Say we have to encode retention rules. To encode those rules, a programmer must definitively answer, permissible according to whom, in what context, for which data category, and under what circumstances. So to replace human legal judgment with code, that developer has to lock in answers to these questions. What if the data is lawfully held for some sudden litigation? By forcing this, we aren't really automating the law. We're just making a stressed-out software engineer make massive legal judgments. Judgments that, frankly, seasoned legal teams and Supreme Courts still fiercely debate. Which naturally brings up the second critique. Who audits the auditor? The meta-accountability gap. In the system we have now, if a compliance officer messes up, that's a human decision. It can be traced, it can be audited, it can be argued in a courtroom. I mean, armies of lawyers exist literally to catch each other's errors. But if an algorithm enforces compliance incorrectly, it does so invisibly, at scale. It makes the exact same mistake across millions of transactions in a fraction of a second. If you remove the human adversarial layer, you completely remove the primary error correction mechanism of the entire justice system. And we have to talk about the stakes here, because they are astronomical. 250 crore rupees. Under India's DPDP Act, penalties for violations can reach up to that amount, per violation. Think about that for a second. If an enterprise installs this government-backed automated compliance system and the algorithm glitches or, say, misinterprets a new type of data transfer, causing millions of accidental automated violations, who pays? Is it the enterprise's fault? The software vendor? The government ministry that approved the base code? The source notes this isn't some theoretical thought experiment. This will absolutely be the very first legal dispute the moment this system goes live. Relocating vulnerability from legal ambiguity to brittle software. This is the third flaw reported in the text, and it's all about the very cyber threats this system is supposed to stop. The government's justification points to AI threat models that can find system loopholes human experts might miss. But our source argues that law to code doesn't eliminate these threats at all. It just relocates the vulnerability. If your entire legal compliance system is literally just software, sophisticated hackers don't need to outsmart lawyers anymore. They just need to find the specific conditions where the compliance code produces a false positive or an exploitable edge case. You haven't fixed the problem, you've just created a massive new attack surface.
Let's do a quick comparison of the two paradigms. On the left, the legal system. It adopts to new interpretations, handles novel cases by analogy, and accounts for context. On the right, the encoded compliance system. It requires software updates, undefined cases cause errors, and it only evaluates defined conditions. So our organic legal system naturally evolves, right? Judgments reinterpret statutes, judges reason by analogy. But an encoded compliance system, it ossifies. A rule coded in 2024 enforces the 2024 interpretation forever, unless someone shells out for an expensive, risky software update. As the source warns, embedding compliance into slow legacy software in a rapidly changing environment like data protection is a highly risky bet.
Who writes the base code writes the law. Now, this introduces a really profound political economy argument. If a government body, in this case the IT ministry, writes or approves the foundational base code for how the law is interpreted, they effectively bypass the elected legislature that wrote the law and the courts that are constitutionally empowered to interpret it. The appearance of algorithmic objectivity kind of acts like a shield. It allows a centralized body to encode their preferred legal interpretations directly into the infrastructure itself, completely sidestepping democratic oversight. Then we have a highly practical limitation. The cross-border data problem has no algorithmic solution. Data just doesn't respect national borders. A single transaction might involve an Indian user, a server in Singapore, a multinational cloud provider, and a US-based engineer. So how does one single algorithmic codebase simultaneously satisfy overlapping and often conflicting global jurisdictions, like the US, the EU's GDPR, and India's DPDPA? Well, the source points out that it can't. No single algorithm can resolve these jurisdictional conflicts without producing just endless contradictions. Speed is a false virtue. Fast enforcement of a wrong rule scales harm. Here, the source is challenging the absolute core premise of the government's argument, the idea that speed is inherently a virtue. Yes, obviously AI operates at machine speed, but the text warns that while fast enforcement of a correct rule is great, the mathematical certainty of software bugs means fast enforcement of a wrong rule is categorically disastrous. Because at machine speed, the harm scales exponentially before a human even realizes what went wrong.
The chilling effect. Automated rejections without human context. This rapid, unthinking enforcement creates a massive chilling effect. Just imagine legitimate, life-saving data activities by medical researchers or frontline healthcare providers operating in really complex situations. Their actions could be instantly rejected by a machine that just cannot understand human nuance. And because it's an automated rejection rather than a reasoned human ruling, a lot of people might not even bother appealing. They might quietly shut down vital, completely legal work just because the algorithm said no. So let's look at this breakdown. On one side, we have automated compliance tooling. This is genuinely useful, widely deployed, and automates operationalization. On the other side, we have automated legal interpretation. This is constitutionally fraught, it's novel, and it means software determines legal violations without humans. The author isn't saying AI has no place here, but they are making a really critical distinction. Building tools that help humans operationalize compliance is genuinely useful, it's widely done. But handing over the actual legal judgment to a machine, letting software determine violations entirely without human review, that is a poorly understood concept where all these structural weaknesses live. The solution: machine speed monitoring with human-in-the-loop authority. So what's the alternative here? The source outlines a much more defensible, modest architecture that resolves this whole tension. Instead of an AI that automatically issues a 250-core Ruby penalty, we build AI that operates at machine speed to monitor and flag probable violations. But, and this is absolutely crucial, it pushes those flags to a human for review and final decision-making authority. It marries the speed of the machine with the context and the accountability of a real human being. If the code becomes the law, who really holds the power? The elected lawmakers or the engineers who wrote the base code? I want to leave you with this provocative, underlying structural question posed by our source today. As we rush to secure our digital borders with artificial intelligence, we really have to ask ourselves, if the code truly becomes the law, who holds the power in our society? Is it the elected lawmakers representing the people, or the unelected engineers quietly writing the base code? It's a massive question of democratic accountability, and we need to answer it before we let algorithms take the wheel. Thanks for exploring this explainer with me.